missed anything. Perfect. And I'm going to invite Natalie Giroux to introduce herself and kick things off.
Hi, everyone. Can you see my screen?
Yes, we can see your
Okay.
screen. Looks great. Thanks, Natalie.
Yes, so my name is Natalie. I'm the president of Stratford Intellectual Property. I've been doing IP work for over 25 years, starting at Newbridge Networks when we got sued by Lucent for infringement of 5 patents that were standard essential. So I kind of fell into IP by accident, but it became a passion because I believe the biggest mistake we do with IP are done very, very early in the stages of a company. So that's what I'm trying to do, is try to evangelize the things we need to be careful about. And I also spent 6 years working with Skypoint Capital we were doing investments in seed stages and Series A. So I've been doing a lot of due diligence from an IP perspective on many startups. And then my role was also, once we invested in a company, to actually put them on, like, design their IP strategy and implement it with our companies. So a lot of what you're going to hear today comes from that perspective, as what, when I was an investor. It also includes a lot of content from one of my colleagues who's been involved with some of our clients through acquisition by Nokia and really large companies. So, and also investment rounds, when what they were looking for in terms of giving money to companies. So feel free to stop me if you have questions. I'm happy to entertain questions or discussions throughout. I don't have a lot of slides, so we have time to discuss. So today I want to cover what's an IP strategy, what's the importance of IP and M&A and fundraising, what impacts valuation, what the investors are looking for, and consideration on IP monetization. And then I'll give you what I think should be something like a 10-second IP pitch that you could customize for your own investor presentation. So a lot of people think I have a patent and a trademark, therefore I created this moat around my company and I now have exclusive rights to develop and sell my product. But the reality is IP is more than patents and trademarks. It's a whole bunch of things that you need to do to protect yourself and to make sure that you maximize the value and reduce risk. And today it's going to be really the theme of what I want to talk about. So it's more having a castle with drones and all sorts of other protections that you want to put around your company. So just quickly, in terms of IP, we're talking about patents, which are registered IP that protect functional inventions, so how something works. Patents will give you protection in each country you file into, so that, if you don't file in a specific country, people are allowed to use the invention that you've disclosed. Contrary to that, we have trade secrets, which protect anything that in your company that remains secret, including your business plan and things like that, but can also protect functional inventions. So by those staying secret, you now have some of your secret sauce that is stays unpublished and give you a much longer market advantage. So there's benefits to patents and trade secrets. That's not really the subject of today's presentation, but I think it's important that you consider both types of IP when you discuss with investors. Obviously, there's trademarks, and I would assume all of your companies have trademarks, and copyrights, in which case that typically covers literary work and also software, and we'll talk about some of that later. So IP strategy needs to cover all these different types of IP, not just patents, not just trademarks. And what we're trying to do here is to maximize value and making sure that you spend your money efficiently in protecting these assets. That's definitely one thing an investor wants to know, is that you know why you spend the money and what is the long-term cost of the filing strategy that you've selected. And that's another discussion we'll have today. Also, we want to make sure that your IP strategy is designed to avoid loss of valuable IP. And here we're talking about having regular IP awareness sessions with everybody in the team, so that all employees respect IP and make sure it's not disclosed inadvertently. And of course, investors are not really happy when there's infringement claims, so we want to minimize risks by doing proper IP searching. So why do we want to own IP and to have an IP strategy? It's to increase business value, as we talked about, but also finding opportunities for collaboration and facilitating access to financing. Investors see in IP innovation, and that's what they're looking for in terms of investment, looking at businesses that are disruptive and changing the industry. Also, the valuation of companies have changed greatly in the last decades, and now is primarily focused on intangible assets, which are generally all the different types of IP I discussed earlier. So what's an IP strategy? It's basically combining all these different types of IP and then developing the proper culture. I mentioned IP awareness, respect for IP, having the right strategy for filing the IP across the world in a pragmatic and efficient way. It's managing the portfolio properly so that, you know, an investor comes in to do due diligence, nothing is missing. We'll talk about that. It's also using patent databases to gather industry intelligence and to make better business decisions based on what other people are doing with patents. And finally, much longer term is monetization, but that's something that still needs to be in the back of your mind when you file for IP protection, because the success of monetization depends on what you do early on. And all that needs to be obviously managed through some kind of IP governance at the executive level. The key here is that IP strategy is not just a one-time, okay, yeah, I thought about everything. It's something that needs to be done in a proactive and intentional manner on an ongoing basis. And it's something that needs to change as your business objective and your business plan change. So it's something that's live. It's not just something that you wait and just be very reactive. Oh, I have an idea, maybe I should patent it. You contact your patent agent. They contact you when they have an office action. It needs to be much more lively, much more proactive. So the first really important piece here today is public disclosures. So if you make any kind of public disclosure about your innovation without proper protection, you basically risk to invalidate your assets in the future. So what is a public disclosures? Is any kind of verbal or written form that describes how something works. Once you make your product available for sale, regardless or not whether or not people have signed NDAs, then it's a public disclosure. Most countries will not give you any kind of grace period. So the minute you make a public disclosure, you cannot file for your patent protection in those countries. That includes most countries in Asia and Europe. The only exception is Canada and US that give you a 1-year grace period. But we often see our early stage companies that did not have funds to protect IP, who made public disclosures, and that 1 year, even that 1-year grace period has gone by. So a lot of investors do not like to sign NDAs, and this is where you need to be really, really careful. You want to discuss with the investor what the product does. So what are the results, the value of the solution that you're providing, but you don't want to get into the detail on how it works, because that is what could be in the patent that is filed, and that would create a public disclosure. And more importantly, if it makes sense to keep that as a trade secret, you definitely never want to disclose that to anyone without NDA. And even with an NDA, you need to be careful to manage your NDAs properly.
Natalie, we just have a question from Tally.
Yeah.
Tally, I'm not sure if you want to unmute and go
Hi.
ahead and ask.
Yes. Yeah. Sorry, I can't do my video now. I'm at a hair salon, but you don't want to see me right now. But my question is this. This is you. I just want to understand one nuance. Maybe can you hear me? Are you able to hear me?
Yes, we can
Yes.
hear you.
Yeah. Perfect. Okay. So now you're saying don't tell people how it's done. You just tell people what's done and the value. But when you sell the product, is that essentially, does that cover how it's done? Or can you sell it, can you sell the product, but not have that be considered a disclosure? If you're not telling your customers, let's say, how this solution works.
Yeah, that's a good question. Unfortunately, the minute you sell your product, you're also selling the how it works. So you are making a public disclosure. So even if it's not visible to the public how it works, you are making a public disclosure of the invention from a patent perspective. However, if your innovation and all the algorithms are implemented in the cloud and it's just, the results that are shown to the user, you can still keep that as a trade secret, and that would never become visible to the public, and nobody should be able to access this code unless they do something illegal. So it's a public disclosure from a patent perspective, but not from a trade secret perspective.
So I see. So you can sell and still retain trade secrets, but not patents. Now what if you're not selling, but you're having people test the product? So they haven't paid you anything, but they're using it like as testers. I guess
Then you need to give them, make sure to sign NDAs before they test it.
okay. I guess you can't do that with customers, right? That's not
Right, so at
possible.
that point, you have to rely on the 1-year grace period, but even better, I would say, try to file a patent application that covers what you have that they're testing. At least then you're protecting yourself. And if you're filing a provisional in the US, then if you decide to keep as a trade secret, the provisional will not publish.
Thank
Wonderful. Oh, while we're on a pause here, my mistake. I didn't invite Kim Butler to introduce herself to the group when we kicked things off. Sorry about that, Kim.
Not a problem. Thank you. So I'm just sitting here listening and learning from Natalie as always. I think has a wealth of knowledge, and every time she speaks, I learn something different. But I worked for about 35 years in technology-based companies, and certainly IP has been a key component of any strategy through software development, and more importantly, through investor rounds that I've done, and also through acquisitions that I've led through various companies. So it is a super important topic, and I think that Natalie touched on it earlier. It's not a task to do, but it should be part of the cadence of how you operate your company and what you how you conduct your business. So we'll talk a bit more about that later on, but certainly I can help support and attest to that. I'm also a very happy coach for one of the cohorts here. So with Elena and B Vector. So and I've been involved with SheBoot since the beginning, in terms of providing coach and some other perspectives of working through startups, through through to IPOs, acquisitions, worked in multinationals, and gained back in startups, and done it a couple of times. So hopefully I can answer some of the IP questions for you as you go through. So
Thanks so much, Kim.
thanks, Katie.
Back to you, Natalie.
Yeah.
Sounds good. I see a hand up. Is that still another question, or?
Tally, do you have another question, or is your hand just stuck up?
Oh, sorry, it's just stuck. I'll
No
remove it.
So I wanted to now touch on why IP strategy is important in M&A and then in fundraising. So one of the goals of your company might be to exit through M&A. And this is where your IP strategy needs to start from day one, so you do things right. I mentioned the potential to combine trade secrets and patents to increase value of your company. We're going to talk about trademarks in a minute and also to copyright. So why would a company acquire your company from an IP perspective? Is because you have assets that could help them exclude other competitors from entering a market. They may acquire your IP and your company to use the IP for defense in a litigation. That's another good reason. They want to generate new revenue. They want to add features to their product that is covered by your IP, and they want to increase their own company value. So when you start thinking about your own IP strategy, this is something you want to keep the end in mind, right? So you want to see like, why am I filing this patent? What am I trying to do in the future? And we'll cover some of that in later in this presentation. So what's the importance of IP strategy and fundraising is because you want to showcase to the investor all the IP you have to make sure they include that in the company valuation. Very early stage companies, they'll take any kind of valuation from an investor, but you should negotiate with the investors to take into account your trade secrets and your patents and your trademarks in increasing the valuation. Those are all very valuable assets, and that's a discussion you should have with the investors. You want to basically give the investors a view on what's innovative in your company. So when I mention trade secrets, what's really important here is to catalog your trade secrets. So each time you put something innovative in an algorithm that you want to keep a trade secret, have the cadence of using an Excel spreadsheet and add lines to say, okay, we just invented a new way to parse, large data models to extract something. You don't explain how it works, but you just give a name to all your trade secrets. Over the year, you show that to investors, you have 7 trade secrets and 2 patents. The investors will see a lot of value in that. But it takes good rigor to keep adding to this catalog of trade secrets. And companies don't think that way. They say, oh, we're not going to patent this, we're just going to leave it there. But without being able to catalog it, you can't show value to the investors. The investors will do patent searching. So if you have your IP portfolio, your trade secrets, they will do searching and get experts to do searching to see what your competitors have and compare that, right? So you want to make sure that you do proper searching yourself to be able to explain to the investor your IP position against your competitors. And then in some case, when you're fundraising, the investors will use your IP as potential security in case of default, and then basically have the IP belong to them if there's an issue in the future. So what impacts valuation of your company from an IP perspective? I just mentioned a catalog of trade secret that is really important, but also having proof that you have proper cybersecurity. So if you have trade secrets and you have a development environment that's not properly protected, you risk to lose your trade secrets, and then the value goes to 0. Same thing if you have these trade secrets are running somewhere on a cloud server, you want to make sure those are very secure, and very importantly, the transfer between your development environment and the cloud server has a lot of really solid cybersecurity. Yes, there's a question.
Yes, right, thank you. So we currently have we use Firmex as a data room, but we have a separate section that's not accessible by anybody other than myself and my CFO, that we're keeping our trade secret login Is that the kind of thing that you're talking about? Because I'm paranoid about keeping anything on a laptop or so I've just used the data room knowing that it's got the security there. So is that the kind of thing you're talking about, or is there something else that you would recommend?
Yeah, the trade secret log itself should be at a high enough level that it's not that dramatic if you lost it. I'm more worried about the actual code that implements those trade secrets.
Yeah.
And then the risk that someone can hack and access it. The minute that's accessed and put in the public, you've now lost your trade secret.
Yeah.
This is where the paranoia should be on protecting that development environment, the place where the code is executed, usually on the cloud server, and the transfer piece where people can hack the communication channel in between your development environment and the cloud. So
Right. Okay. So it's actually, so yes, we're a biotech. So things like our lab notebooks and all of that experiment that's feeding into something which is going to be ultimately fileable.
yeah,
So that information itself needs to be kept in a secure place.
definitely. Yeah.
Okay. Yeah, and I'm not an IT person, so I'm extremely paranoid about everything on this.
Yeah, I'm not an expert in IT, just IT, but this is a really important piece if you do have trade secrets. Another way that you can easily lose your trade secret is with people just writing down things on whiteboards and leaving that in the office at night, right? I often give presentations like this in person in a conference room that would have like an entire architecture diagram on a whiteboard, and it says do not erase. And it makes me laugh because at night you have people coming to clean that can just take a picture of this, throw that on the internet, and you've lost your differentiator forever, right? So and even though it's patented, sometimes not everything goes into the patent. So it's really worth being paranoid about not leaving things behind. You mentioned lab books that are, if they're not software lab books, they're hard lab books, people can forget them at a Starbucks, right? So that's also really dangerous.
And I'm things like, privacy screens, like nobody's allowed to put anything on a computer if they're traveling. Whenever we're having conversations, I always make sure that people are in a room and not in an airport. It's Oh, okay. No, that's helpful.
Okay. And then the other thing that positively impacts valuation is keeping open patent families. And your early stage companies, this is something for a few years from now, but just before a US patent issues, you have the opportunity to file what we call a continuation that gives you the opportunity to change the claims in the future. That can actually double the valuation of your IP portfolio if you keep these patent families open in the, on an ongoing basis. So that's something definitely worth discussing with your patent agent. But of course, this usually is like 2 to 5 years down the road, but it's something to keep in mind. Your IP strategy should have a comprehensive data strategy. Where's your data located? Is it properly marked with copyrights? Is some of the data actually one of your very important trade secrets, in which case it should go on the trade secret log. Trademarks. So I would guess I reviewed all your companies. I was actually very impressed with all the technologies you guys are building. So congratulations. And what I did not see is on some of your website was just the word TM, the superscript TM beside your company name. That is free, costs nothing, but it starts the clock rolling on your ownership of this trademark in the future. So your logos, your company name, your product names, anything that differentiates your brand, put TM on it. It's easy, but it's really important because once you have the funds or you want to register the trademark, if there's any kind of opposition to it, you can actually refer back to the date where your website had the TM on it. And TM is your intent to register a trademark in the future. So it doesn't, and you may actually abandon the mark, it doesn't matter. But if you do go to registration, taking that step, that free step of marking TM is really, really important. And also securing the domain names. So right now, the law between domain names and trademarks is not related. So if you have your trademark, you even go on to register it, but you didn't secure all the domain names, you may have some very sad surprises in the future. One of the companies from SkyPoint had registered just a few domain names and forgot some important ones, and ended up someone had put a porn site on that domain. So that was pretty catastrophic. We tried to get them to stop, but because the trademark laws and the domain names are not interconnected, there's nothing we could do. Before joining Stratford, I had a company, a consulting company, and I secured a domain name called Enabling Ideas. I thought that was my consulting company name. And some company, a big company, came to me and said, we believe this is our trademark, and they had not filed a trademark, but I had put the TM on it before them and proved it to them. Turns out I joined Stratford and I was able to make a lot of money selling my domain name and the trademark to them. So these are simple things you can do, but if you do them early on, you're going to be really, really happy in the future. Registering trademarks is not very expensive, but it's, given you're probably really tight in funds, is something you can delay as long as you mark the marks properly with the TM. Another thing that proactively impacts valuation is having a documented IP strategy, which is basically documenting everything we talk about today in a way that an investor can say, okay, like this company understands IP, they know what they're doing, they're proactive about it. So it gives me a lot of confidence in the potential success of the companies. And then organizing the files with proper chain of title, I'll get to that in a minute, but that's also very important. And from an investor point of view, having a long-term budget, and we'll discuss that as well. So on the other side, what decreases the risks? So an investor looks at your company and they're going to say, like, do you guys have regular IP governance? Do you implement your IP strategy proactively? From a copyright perspective, I mentioned it covers all the literary work. So all your website pages should be marked with copyrights. All your user documentation should have the proper copyright clauses. But what's really important with copyrights is your use of open source licenses. So I don't know, I can't see everyone, but I'm curious how many of you guys use open source in your software. But I guess I could see. So the key here is that not all open source communities are created equal. They all have their own compliance requirements. And even more importantly, some communities require you not to mix with other communities. It's pretty complex. But before including all sorts of different open source, you need to educate yourself with what you can do to avoid issues. So one example is one of the SkyPoint companies. They built a product for 5 years. We funded them, and they got to a point where Siemens came in and made an offer to buy the company. They went through the entire due diligence, the patents, everything. Everything went fine. We scheduled the closing dinner, and then they ran a scan of the software, and they found so many communities of open source that were in conflict. They realized the company had not been compliant to their requirements, and they canceled the deal. It took that company 8 months to rewrite all the software, but by then it was like the doomsday of telecom, and the Siemens never acquired the company. So this sounds simple, but it's really, really important, and it's worth for you to spend time to understand what open source licenses you're using, and to have a policy in your company. Your companies are going to grow fast. You're going to hire all sorts of designers. They need to know what they're allowed to do. So either your policy is we are not using any open source software, which may slow down your development. So I'm not saying that's the right answer. The other side of the policy is everybody can do what they want and we'll deal with the risk in the future. I tell you that investors are more and more knowledgeable about this issue. So this may not be the right answer. And there's the in-between, where you have one person in the company that's accountable for keeping a list of open source software that will, manage any kind of new open source people want to bring. And then that person also scans the software maybe twice a year to make sure there's no bad surprises.
Natalie, we do just have one question. One of our founders always never has access to a raised hand. So Bronwyn, I'll just invite you to come off mute and ask your question.
I think Katie doesn't like my question, so she's like muted me from ever asking anything. No, I'm just kidding. But I'm sorry I don't have a raise hand function. I was like, my question is just in several conversations. I mean, I definitely have heard the value of doing trademarks. This is a trademark related question. But then I've also had a few conversations with investors who are like, why would you waste the money doing trademarks? Like, that's not worth anything. And I'm like, interesting. So to us, where we have like, I feel like we've been in the public eye in quite a few scenarios through events and conferences and everything, like have a pretty public facing market. I feel like there's value because people now know it kind of like a brand, and we also trademarked the brand and the product name so that both of them had a trademark, not just the in case it changes. But I've been told from investors like that was a waste. I don't know why you did that. And I'm like wondering what your thoughts are, opinions on that, and how much of a value do you think it really does provide?
Right. So as I mentioned, early stage, just use the TM is fine, but you have to remember that filing trademark registration is a first to file issue. So if you don't file and someone else goes, oh, that's a really cool name, they can file the application before you. And then you have to fight with them to show, well, I was using the TM if you were, and that could help. But some of your competitors may actually file that exact same trademark to prevent you from moving forward. And having to rebrand is really confusing for companies. Filing for trademarks in Canada and US, we're talking about a few $1,000s. We're not talking, it's not like a patent, right? So I think the drawback of not filing and having to fight or to rebrand is much more expensive than the cost of protection.
That was helpful. And I also, claim to it was covered with grants. They're like, but you could have used the grants on the other thing. I'm like, well, it was an IP grant and that was part of the budget. So here we are. They were filed and it was a good thing. And everybody laughs as a fun side story to tell us all. I got the tattoo of our logo on my ankle and everyone's like, what if your brand changes? I'm like, then it was a good memory while it lasted. So I said, at least I have a filing date on my leg. We're good.
Yeah, exactly. Okay, so then what's the next thing that investors want is to see proper IP clause in all contracts. What does that mean? It means that founders have an IP assignment clause to the company. So a lot of founders we meet don't even have an employment contract with their own company. Often 2 or 3 people will start the company, one will leave, their name is on a patent. And now we have no way to get a signature because there's no agreement of assignment to the company. So this is one of the biggest mistakes I've seen. And it actually, in a few cases, forced us to abandon assets because we could not get a signature from someone who had left, and we could not use a contract in lieu of the signature. So making sure if you don't want a full employment contract with your company, make sure there's at least an IP assignment clause with the company that can be used in the future. Other contracts like supplier contracts should have IP indemnification clauses. Research agreements we'll talk about in a minute as well should have the proper IP clauses. So Generally, contract templates have IP in it, but if there's no IP in a contract, that should raise a flag to speak with an IP person to help you put the right clauses in there. IP searching. So there's huge database of patent information all over the world. And there's different searches you can do to help you understand what's out there. So a landscape search is usually something that's done using keywords that represents your innovation. And this will pull all the top patents that are the closest to what you're doing. That can help you figure out, like, is what I'm doing very innovative? Is there a risk of infringing a third-party patent? If so, what kind of contingency do I have to get around them? Then there's competitor search, where you're actually looking for the patents of each of your key competitors to see what they're doing. And what's really, really useful with these searches is when you do them again in a quarter, like in 3 months or 6 months, because then you can see how the landscape is evolving, what your competitors are publishing, which tells you what they're focusing their R&D on. So this IP searching is generally part of an IP strategy, and is one of those things, when I said being proactive and being intentional, is something that you do to give yourself more intelligence about the industry you're in. We talked about cybersecurity. We talked about IP awareness, that is really important. And this is not only for the founders. We want to see IP education across the company. I mentioned my whiteboard example. And then there's regular IP monitoring. So to decrease risk, you want to make sure that you regularly look for other people that might be doing the same thing as you. And if you file a patent, this way you can detect infringer early and act strategically, which could mean modifying the claims of your patent in a way that is much closer to someone infringing. One of our clients did that exactly. They found someone that was offering a feature that we had patented. The patent was issued. We had filed a continuation. There were a few words in the claim that were not exactly like what the competitor was doing, but we had the opportunity to change the claim, get the continuation to issue, and in a week, the competitor removed that feature that was actually really cool, but they removed that from their products. So doing the monitoring is really important. And then having policy on the use of AI generated content to avoid copyright infringement, but also to avoid public disclosures. So there's 2 Samsung employees that had a bug in a piece of their code, and they thought to ask ChatGPT what the problem was with their code. So they put the code in ChatGPT and basically made a public disclosure of a piece of code that was a trade secret. So there's a lot of risks around AI in terms of IP that you need to be aware of, and making sure part of the IP education and awareness of your team that everybody's really, really careful about what they do when they use AI. So now I have a bit of a checklist, probably just rehashing some of what we've talked about. And I think we've shared this presentation with you, but I have it in another format that we can share. So what are investors looking for? Clean ownership of IP with proof. So make sure when you file a patent or a trademark, when the agent sends you back all the filing receipts, that you start building a really clean database, like a folder structure with everything on it. The last thing investors want to see is a last-minute struggle to find assignment documents, declarations, filing receipts. This should be all in a folder that you share, and it should take minutes to be able to share that. You know, a lot of people keep that in their emails and then they forget an email, or sometimes the agent forgets to send filing receipt. Before you pay the agent, make sure you get all the documents on your own file structure so you can share with an investor. As an investor, I used to judge the executive team based on how complicated IP due diligence was. I could not believe people would go and spend $25,000 filing patents and they had no receipts to prove for, right? So this is easy, it's boring, but it's a good way to manage the assets that you invest in. So, of course, investors don't like litigation or notices of potential litigation. So if there's anything like that, you want to make sure it gets resolved before you go to funding, or at least you have a path to resolution. No disgruntled employees who have not signed IP assignments. This brings me back to making sure that everyone has signed IP clauses in their employment contract that gives automatic assignment to the company. We want to see IP properly marked. So I mentioned the TM. Once it's registered, you mark it with the R, the registered, but also marking patents. So as you start filing patents, somewhere on your website should be clearly saying patent pending. As the patents publish, you put the publication number. So continuously updating a web page that has all of the patent information. Why is that important? Is that if you ever find someone who's potentially infringing, you can claim 7 years back damages from the start of you marking your patents. And you, by marking in a way that's easily visible to a client, to an infringer, you can potentially also claim triple damages because it becomes willful infringement. Of course, investors don't want any kind of outside funding that has lien on the IP. There are funding programs. One is, for example, the BDC IP-backed financing, which is a great program. They will put a lien on the IP. So you want that to be very clear with the investor from day one. And then make sure that's not going to be an issue down the road when you're getting close to getting your financing. You want to manage your NDAs properly. A lot of people sign NDAs and don't track expiration dates, who they've signed it with, whether they've signed it with one person or the entire company. And then they start making public disclosures because they don't realize the NDA is no longer valid or it's not with the right person. So having someone on the executive team that manages the NDAs very carefully and limiting how many people are allowed to sign NDAs left and right is really, really important. We want to have clean patent prosecution history, and again, keep the files. So if there's an office action on a patent and the agent provides a response, keep that in the folder with everything else. Everything should be together, very, very well organized. We talked about doing searching. We talked about open source. These are also very important pieces. And if you've licensed your IP to a third party, there should be a process to monitor revenue that you're getting. And on the other side, if you're licensing from a third party, we want to make sure that you have a proper process to pay royalties to make sure there's no issues down the road. I mentioned leadership team knowing what the IP landscape is, but not the landscape a year ago, on an ongoing landscape. Yes, there's a question.
Yes, I have a question on the previous slide. My company is looking at the IP sub-licensing model, and here you're saying we should have processes to monitor revenue. Could you kind of explain more this fact?
Right. So if you're licensing your patent to a third party under like some kind of an agreement where they will pay you like 2% of their revenue for these products, you want to make sure that, well, one, they pay, but you have a process where you can check and make sure that you see what their revenue is. So part of your agreement in the licensing is that they have to provide you with a clear view of the revenue like they have to show you their books, basically, so that you can make sure you're getting the money that you should be getting.
Because we are a small company at the moment, and we see this being very complex in the future to access to the books. It will be really expensive. We are looking at a fixed royalty fee payment. Have you seen this before?
Yeah, and that's definitely a lot easier, a lot simpler. And as long as it makes sense for you in the future where you're not leaving a lot of money on the table, it's definitely easier. And you could have like another model I've seen recently where it's a fixed fee for the first 5 years. And then ongoing is a percentage, and that gives your company the time to grow and have the people that can handle the royalty stream in the future.
Yeah. Okay, great. Thank you.
Okay, so the rest of my checklist on what investors are looking for, we talked about making sure that the executive team has some competency on IP. And at the end, I'll talk about funds that are available in Canada, and that includes funds for IP awareness. Today, this webinar is not about IP awareness, it's more about looking at IP from an investor's perspective, but there's a lot of good IP awareness programs that you have access to that are free. And it's worth going through that to make sure that each type of IP is well handled. And that's something investors want. I think I've mentioned a lot of these points already. Ongoing R&D idea capturing, that's also really important. So we talked about the trade secret catalog. We talked about having like some patents, but having another way, and there's a lot of really cool online systems that are secure where people can just throw in their ideas. So they're working on something and they have to deliver a feature, but they're thinking, oh, this would be a great feature for the future. And then you have this idea capturing system that will feed either your patent portfolio or your trade secret catalog. So starting that kind of process early on develops a culture of innovation in the company that can change how people are handling innovation and IP for you. The IP budget is really something that people don't think about from an early stage, but is really important. When you file for a patent, and trademarks is not such a big issue in terms of cost, but patents can cost a lot of money, not only when you file them, but in the future. And too many early stage companies file a US patent, and then the agent says, oh, why don't you file the patent cooperation treaty in case you want to do more countries in the future. So they invest in $20,000 for US and PCT. And then in 30 months, it's time to choose like what countries the PCT will be filed into. But the company has not planned any money for that. So there's no money for foreign filings and the PCT is abandoned. And basically that was a $6,000 waste of money early on. So when your agent offers you to file, PCT as a placeholder for future filing, somewhere there needs to be a budget that is at least 3 years, if not 5, of money you're going to need to invest in terms of foreign protection. The other thing that's always missing in the IP budget is the cost of prosecution. So when you file a patent, a patent examiner will look at it, will do a search. Generally, they refuse the first, filing with a whole bunch of reason, which requires your agent to provide a response. And then this can go on 2 or 3 times. So it's a back and forth between your patent agent and the examiner. This costs, depending on your service provider, between $5,000 and $15,000 each time. So typically, a patent application will get at least 2, if not 3 office actions over 2 to 3 year period. So if you have not budgeted for these costs, you maybe end up having to abandon your patent application, and you basically have wasted money. But more importantly, your patent is now public. It's been published after 18 months, which means it's available across the world and you've lost your protection on it. So this long-term budget is not easy to do, but your agent should be able to put that together for you. And this is something you have to keep in mind if you don't want to lose your assets. I think eventually we're going to have some really nice tools available to do long-term IP budget, but right now, think 5 years down the road and a rolling 5 years. Each time you file something new, it's a new line on your 5 years budget for the cost and all that. Also, there's lots of cost deferral and cost reduction services for patent filings. Not all agents will mention that for obvious reason, but for you, an investor would like to see that you're using these cost deferrals, these cost reduction services. I mentioned the Patent Cooperation Treaty. For a patent, you file at the PCT and you now have 30 months to decide which countries you want to go into. So it's a 6,000 investment on day one. In 30 months, then it's going to be like, think 5,000 to 8,000 per country. So if you want to go to Europe, Japan, China, depending on the countries, your bigger investment is now 30 months down the road. And this placeholder just gives you time to develop your product, your markets, to make these decisions. And then cost reduction. There's another really great program called the Patent Prosecution Highway. And what this does is that if you get a patent to issue in one country, preferably in the US, you get this issuance to convince the other examiners in all the other countries to skip the prosecution process and give you an issuance right away. We've been very successful on using this program and saved like tens of thousands of dollars in each country. So these are really good programs to look into. And then ranking patent families. So as you start filing different patents for different features and different things, you have to realize that not all patents are created equal. Some are like groundbreaking technology, generally your first patent that led to the creation of your company. And then the rest is like additions and increments on this groundbreaking patent. A patent that's deemed standard essential is a lot more important than one that's just a slight modification to that. So that should, those considerations should be used to justify the countries you're investing into. A standard essential patent you would want in a lot of countries, while the additions to this patent would be in probably maybe just in the US. So when you discuss with your investor, they're going to say, well, what was the rationale for you to file and spend $60,000 in these countries? Then you have to have like a good answer to that, not just, well, my agent told me to do this. So looking at where competitors are filing, where the potential acquirers are filing, these are good, also good data point to help you decide where to invest, because it gets really expensive really fast. One of our clients, their end goal was to license to Samsung and to LG. So all their fundamental patents we filed and prosecuted in Korea and Asia. And they were successful at getting really lucrative licensing programs because we had thought early on into their endpoint, which is what they wanted to do with their IP in the future. So some of you might decide to work with universities to speed up development and research for your product. So as an investor, they see very positive this research collaboration because it makes the R&D a lot cheaper. However, in a lot of cases, IP ownership is not clearly defined in the research agreement. And why? It's because it's complicated. So people try to get these agreements done quickly and they just leave the IP on the side. But it's too late. When the project is on its way and it's becoming successful, it's too late to actually start negotiating these things. So take the time early on to agree on the IP that's going to be created and who's going to own it. There's two models. One is the university has ownership of the IP. They will pay for all the costs involved with the patents. And they give a license to the company. And then you need to negotiate, is it an exclusive or non-exclusive license? All of that will have impact on the valuation of your company. The other model is the IP is owned by the company and the company provides a non-exclusive license to the university for owning. The company is responsible for all the costs related to this IP, but it also has the account, like they do what they want with it. So if you own the IP, you can do what you want. If you're only licensing the IP, you're dependent on the university's decision on where they file, where, and how they prosecute the patent. Unfortunately, in many cases, because the companies don't, they don't know how to get this done properly, everybody agrees to jointly own the IP. And that's something investors do not like. Because what happened, it's like you jointly own a car with your neighbor, right? They can do what they want with it. I can do what I want with it. But sometimes there's decisions that needs to be done with the car. And if we don't agree, because things have evolved and we're no longer really happy neighbors, it gets really, really complicated. And these are situations that investors do not like. So agree on one or the other model, but try for everything you can to avoid joint ownership. And also make sure that the research organization, if it's the model where they own the IP, they're excluded from licensing to one of your competitors. So you can exclude based on the field or the industry. And that's really important. Any questions? So, so the summary in terms of due diligence and IP, what investors are looking for is be prepared. So keep your IP stuff well organized. It's one of the most valuable assets of your company when you're a small company. And as you grow, it still is very important. So have someone in charge of keeping everything super organized and keeping the agent on their toes to make sure they provide you with all the documents that you need. So basically a due diligence, IP due diligence is basically you're telling a story to the investor through a folder structure, right? So they will judge you based on what's missing and what's not right in how you've organized your IP. So another thing is dishonesty and omissions will kill the deal. So you may be missing files. You may have forgotten to get an assignment signed. Better tell the investor right away, not wait until they find it, or worse, they invest and then something goes up. They want to know ahead of time what they're getting themselves into. So yeah, be proactive in managing your IP. That's the best advice I can give today. I wanted to touch quickly on monetization because that's something that happens way down the road. And it's probably not something you're thinking of, except if you're already thinking about a licensing model early on in your business plan. But licensing and selling IP is a complex process. So basically, you need to, like, if I'm trying to license my patent portfolio to a competitor or sell it to a third party, I have to identify my target, do infringement claims. It's a complicated process. Even though there are companies, mainly in the US, that will do this on contingency. So you only pay a small flat fee at the upfront, and these companies will do all the work involved. It will take 18 months or more. So I had someone who came to me saying, okay, I need $1 million because I'm running out of money. I want to sell 3 of my patent families. And they said they needed the money in 3 months. And I said, we can't do anything for you. It takes a long time. 18 months and a lot more is what it takes to monetize IP for sure. And typically, patents are monetized after 12 to 14 years. So at least from issuance, so you need your patent to issue. And then generally people will be interested to buy these assets when they're 12 to 14 years after filing. The other thing is, generally people have unrealistic expectations about how much a patent is worth. So one patent family with an open continuation can be worth somewhere between 100,000 and maybe 300,000, depending on how fundamental that innovation is. I just had a client who sold 48 patents for $1 million. So it varies a lot, but you know, someone thinking I have a patent, I should get $1 million for it. That's generally not realistic. So having said all that, what I think a good 10-second pitch to an investor as it relates to IP is that you understand all types of IP and you're being careful with all of them. You're proactively implementing your IP strategy. You understand how to maximize value and minimize risks. We talked about all this. You know how much money you need to implement your IP strategy. So you've done a budget. Like I said, trademarks are not expensive, but they're in the low thousands of dollars to file, and then there's fees, ongoing fees, so you're aware of all of that. And you want to say that your employees are educated on how to handle IP to minimize risks of inadvertent disclosure. And then if you have to explain what your product does and the value it has, I would limit to that. So we'll share this, but this is basically a summary of what we've talked about today from on the product development life cycle. So from the ideation piece, prototyping, so everything that we've talked about from the trademark, copyright, trade secrets, and patents is basically mapped here, and we can share this with you after. And then I wanted to touch on the IP sources of funding. In Canada, in the last 3 years, we've been really, really lucky that there's been a big focus on trying to grow the amount of IP assets Canadian companies have. So IRAP, so if your company is eligible for IRAP, they have a great program called IP Assist. They will pay for education awareness. They will pay for a full design of an IP strategy. So think about everything we've talked about today, customized for your company, including doing patent landscapes, competitor searching, and all of that goes into your IP strategy as a start that you can use to implement in the future. And they also will fund things like trademark availability searching and freedom to operate and all that. Then Elevate IP, that's also funded by ISED, but that's funded through the business accelerators and incubators. In Ottawa, we're looking at Invest Ottawa. There's Communitech in the GTA. In Quebec, it's Maine, Mouvement des Accélérateurs et des Incubateurs. So each region has a business accelerator that gives Elevate IP money. What's amazing about this program is they will fund for filing patents, filing trademarks. They will pay all the fees related to foreign filings, drafting, prosecution, up to 100,000 for each company. So this is great money that I'm hoping that, you know, all of you can look into. If patents is not something that relates to your company, they will pay for filing your trademarks. So it's really worth accessing this money. If you're in Ontario, there's a provincial program called IP Ontario. And they're expanding now their reach. Initially, they were all for medical companies, but now that's automotive, AI. So they're really extending their reach. IP Ontario will pay for IP awareness. They will pay for filing as well, IP filing, as long as you're not double dipping. So filing the same patent using Elevate IP and IPON, it's another source of funding. So you can use IRAP IP Assist for IP awareness, Elevate IP for your trademarks, IPON for your patents. Typically, most IP agents are aware of all these programs and they can help you navigate through. And the last one is Innovation Asset Collective. That's another ISED funded program. They're focused on clean technologies. And what's interesting with them is they also will fund your patent filings. And every quarter they give grants for IP prosecution and things like that. But they're also acquiring patents in the clean tech industry, such that if you ever get bothered by an infringement notice, you could use their portfolio as a defensive approach. And BDC IP back financing, this is for companies that have larger IP portfolio, I would say 8 and more patent families, and they will give very favorable financing conditions by putting a lien on your IP. So I think I covered everything. You want your IP strategy to cover all types of IP. IP is really important for M&E, for fundraising. It impacts your valuation and the risks. And investors generally want IP to be taken seriously. And that means not necessarily filing a whole bunch of patents. I repeat myself. It's having a pragmatic approach to what you're doing and understanding what you're doing. It could be in many SaaS companies, the answer is not to file patents, but to use a combination of trade secrets with appropriate cybersecurity. So having that approach and maybe just a patent on the entire framework, that is a much more valuable solution. But you have to be able to explain it to the investors and explain your approach and justify it. So, and I'll finish with the public disclosure. This is probably the most complicated things you're going to navigate, is say enough to the investor to entice them into giving you money. But if they don't want to sign NDAs, don't go into the how your system works. That's it. So we can have questions and discussions. Happy to. And I don't know, Kim, if there was anything else that maybe I missed or forgot.
The only other one, Natalie, that might be worth talking about is we talk about the IP assignment agreement with employment contracts, but it's equally important, might be more so with if you hire contractors coming in to do work for you. So making sure that that condition is covered there as well.
For sure. And the other important one is if you hire students that come in from university, you want to make sure that you own the IP. I've had a case that we had to deal with where the university ended up claiming the rights to the IP that the student created for the company because the contract was not well written.
Yeah.
So that's really important. And when you deal with students, you want to make sure that they won't go and publish their master's or PhD thesis before you had time to file for patent protection. Because they will publish for sure, because that's what university do. But you want to be able to do your protection before they do anything. So that's a good point.
Mm-hmm.
Any other question? I don't know if there were anything in the chat.
So I'll just make one other final comment. Part of this is the culture and the company making sure that you're aware of it from an early stage. So Natalie touched on the employment agreements, making sure that what you're doing, you understand that it's, you know, in your contracts, etc. It's just part of your cadence of how you work, that you're making sure that you're covering off and any kind of innovation, etc., by your employees, making sure that you're patenting them. But it's really a culture in a company from the beginning to get that in place. Because if you start later on and 2 years down the road thinking, oh geez, I got to start to figure out if I've got any patentable items in there, or did I check all my contracts and stuff, it's disaster. So I think it's just my recommendation, start early and just set it up as part of your cadence and your business operations of how you work in your company, and your employees understand that you take it seriously and that's how you work. So
Yeah, and that's a good point, that people start thinking about IP when they get money.
yeah,
By then, the public disclosure has happened, and then you can't file patents.
yeah,
You disclose your trade secrets.
Yeah.
So it's too late. So
yeah, start early.
think about it, and it doesn't mean you have to spend a lot of money. Like the TM piece is free, right? So
Yeah, it's again, it goes down to the culture. I mean, putting in the culture of your company. And yeah.
right.
And I'll say one other thing, just from investors. I can tell you all kinds of horror stories on IP, but not horror, but examples. But the other one, which Natalie noted about pitching to investors and not having an NDA. This, I mean, I've had live experience with this many times. Sometimes investors are trying to figure out if another investment has got enough technology in it. So they'll ask you more questions, not necessarily on your stuff, but to help prove out and to justify an investment somewhere else or prove a thesis. So you have to be really careful that they, you know, if you get into a mode where they say, well, you know, maybe one of your competitors does X, Y, and Z, you don't want to get into that defensive mode of saying, no, but we do it better by doing all these things without having the coverage of IP or NDA. So it's investors will try and find the information around a different way, and it will be, so just be cautious about the questions they ask.
Definitely.
Yeah. And on acquisitions, on M&A too, it also happens there too, but a little bit more sophisticated there. So yeah.
Any other questions, folks?
Someone said they have a question, but they can't raise their hand. Bronwyn?
Oh yeah, Bronwyn, that was earlier.
Oh,
That's
okay,
whenever
great.
I interjected. Yeah, we were joking about how her raised hand never works. No, there you go.
I
Go
have
ahead,
a
Alina.
question. You were talking about valuation of the company based on the IP, and how valuable is this asset to set valuations and everything. But what factors are taken into account to estimate the valuation of an IP? Is the protection geographically? Is how unique?
For
What is
patents, there are known techniques to evaluate the value of a patent portfolio. And there's 3 ways to do it. Typically, it's like how much you spent on a portfolio, and it's combined to how big the market is and what is the market potential, and that goes into like a complicated analysis that can give you a value for your portfolio. And there's other criterias, like if your patents are still open to change the claims, that usually will give a multiplying factor to the value. So it's not a simple science, and it's not a science either. It's like different ways people have combined to come up with a value. Trade secrets, that does not exist, but you can apply the same principle to trade secrets. The idea is you want to have an honest discussion with your investor that you believe there's value in your IP, and that should be considered into the value of the deal when they give you money.
The flip side, though, is not having any IP program or portfolio will devalue, because they will, so they, you know, it's harder to put a number on how much they're worth, but if you don't have a way of protecting your intellectual property or your know-how, or even have considered that, that won't be as interesting to an investor. So there's probably more of a downside than, the upside is hard to quantify, but they're not going to put a line item to say your IP is worth X. They'll put it in the equation.
Any other questions, folks? Oh, should go ahead, Cheryl.
I'm just wondering if there's any like IP ways to address it. So Shopify has a patent for made to measure clothes. It's super broad. It is not specific in any way. And they're not actually using it, but it's just like a random filing because they have a lot of money. I'm wondering like how to get through that in a way that like our system is totally different, that we've been relying on trade secrets. We kind of have used the fact that Shopify has like created this patent as like well, obviously it's a big deal for the future. And they also don't know how to do, like we know how to do this, but they're not doing it, but they have a patent. How do we get around something like that?
So what you have to remember when you look at a patent is the claims. Sometimes you read the patent and it's super broad, but if the claim is issued, they're usually very limiting, right? So there's a bunch of elements. It's a system that has A, B, C, and D. And as long as you know that you're not doing one thing in this claim, then you don't have a risk of infringing. But it has to be pretty clear. If it's really, really broad, then there's a big chance that you could invalidate the patent in the future if it became an issue. But when you look at patent claims, you have like the independent claims that have like basically is a claim on its own, and then you have claims that depend on that independent claim. But if you want to look at a patent, just look at the ones that are independent and make sure there's at least one thing you do differently that doesn't read on that language. And then you have a good feeling that it would not be a problem in the future. They may still go after you, but at least you know you're doing something different. If you're not, then you should think about design around and things to do differently in case you have to. And more importantly, you don't want to write anything down when you do this exercise. You don't want to leave any trace that if they came to you and it ended up in court, that you'd have to produce paperwork saying that you wrote down, oh my God, we're doing this. At Newbridge, when we got sued, we had such drama around what people put in their lab books. It was terrible. They were saying, yeah, we infringed this. And we had to explain to the jury that this person didn't know what they were doing, even though they were like VP of engineering. So just be careful about what you write. And then if you have any concern, talk with your patent agent to make sure that the way you're doing it is sufficiently different from what they're doing. Another thing that I've seen done, and we've done with some clients, if there's patents that are very close, but they're not issued yet, is we filed prior art with the patent office in a proactive manner to influence the direction of how the patent will issue, so that it's not any close to what we're doing.
Okay. Yeah, it's so broad. Like there's no information in their patent. I'm honestly shocked it was granted. It's basically just like, yeah, someday in the future, we hope that someday 3D body scanning can be used for making custom clothes, but there's nothing there.
Right. So probably it would get easily invalidated in a patent trial. Like if you think about it, like when someone comes to you and say you're infringing my patent, the first thing we're going to try to do is get it invalidated in the patent office. And there's the patent trial appeal board, the PTAB, that will look at it, and we give them like prior art and things like that. And 80% of the patents that go in front of that board are invalidated. So.
Wonderful. Okay, we've got to wrap up the session now. Natalie, I want to thank you so much for your time. This was incredibly informative. I've already gotten so many private notes as well, from some of our founders that have just said how valuable this session has already been. So thank you so much, Kim. Thank you so much for your time and your expertise and giving such clear examples of why this needs to be prioritized for our founders. We appreciate you, and just want to thank you for concluding our boot camp in such a great way. So thank you both very much.
Yeah, my pleasure, and good luck for your pitches.
Yeah, and hopefully we'll see you both at, along with all of our founders at the grand finale on November 12th.
Definitely.
Thank you all.
Yeah.
Good luck.
Wonderful.
Good luck, Al.
Good luck.
Okay.
Thank you.
Bye-bye.
Okay, guys, you got to
Bye,
stick
everybody.
around for just a second.
Been a blast.
You wanted me to stay on?
No, the founders. Hopefully
Okay.
Okay, we're all here. Well, majority, if you got to sign off quick. Thank you so much, Natalie.
Bye-bye.
Okay, I'll keep this short and quick, but I did just want to cover off. So we've got a few things. For Friday's session with Nadia, I've communicated this over email, but I just want to make sure that it's clear to all of you that those sessions, I've set up 3 sessions. I've assigned each of you a session to attend. It is in response to a lot of your feedback, which was saying we want to be able to actually practice our Q&A. We want to be able to prep to deal with challenging questions when we're on the spot after our pitches. So we've introduced those as a push to pitch practice. If you can't make the time that I invited you to, there are other options. So you can send me an email, or if you feel like you're good, that's not you'd rather not attend on Friday, or you have other things already in the books, that's okay too. It's all optional. You can also book separately with Natalie to have session one-on-one with her. So just to be very clear, those sessions are optional. I marked you all as optional, and there are other sessions available if you can't make the time slot that I've invited you to. That's number 1. I also shared within the screen, just talking a little bit about the 12th and what you can expect from the 12th whenever you come to Ottawa. So on the 12th that morning, we'll all gather at the TCC Collaboration Center. This is actually the old Shopify office for anybody who's familiar with that building or has attended lots of events there. It's a pretty cool spot. So that's where we'll be all morning and into the mid-afternoon. We've got a program already built in, and it includes lunch. That's why I sent you the dietary restriction form. I think I've already sent it. I'm going to click send to all the forms that I need you guys to fill out, but one of them being the dietary restriction form. I've got a lot of feedback. We want to make sure that there's good food for you guys to eat. So just let us know if you have any restrictions on that side. And then we'll go straight from, so that's at like 150 Elgin, and then at 160 Elgin is where our event is happening. The grand finale will kick off at 3 p.m. There will be a networking period, and then we'll do our 3-minute pitches, and then there will be post-pitch networking. We'll announce the winners of the Shibu Investor Group investment, and then there will also be a networking event post that with one of our community collaborating organizations who's also a part of SAS North that evening. So you'll have an endless amount of things to do. The next day we'll go to SAS North, we'll have the RBCX Tech Mixer, and then the next day we'll have SAS North as well. But just so you do know, we are busy the whole day on the 12th into the evening. And then there are other networking events that are made available to us, primarily with the investor focus through SAS North, because we're sponsoring the investor zone. Is that clear? Cool. Any questions about that? No? Okay, awesome. Also, you will be getting some emails shortly about, you've already received the masterclass invites. You'll be receiving an invitation to a shred workshop. This again is only for those who it's would be valuable to. It's a lunch and learn with experts. So that's going to be on the 5th. I'm also sending a pre-survey so we can know kind of where you stand with shred, if you're filing, etc. And that I've already sent through in the chat. So we'll have all these workshops that are coming through down the pipeline. That is the post bootcamp programming that we make available to all of you. So just know, yeah, I appreciate the thumbs up, because sometimes I get that feedback from founders that are like, okay, all of a sudden I'm getting all these other invites and all this other programming taking place. But we really work to listen to you in terms of what that priority is, and then also carry on your investment journey. We'll have investor and VC lunch and learns twice a month over the next couple of months. We'll also have other resources available to you where you can go to advisors to get, for example, a marketing audit done on your business, and a sales session for those who are really saying, I need support with sales. So there's more to come, but it's just outside of boot camp. And that is that. Tally, you have a question?
Yeah, okay, today's session was very informative, but a little bit overwhelming. Like, how are we supposed to get all this stuff ready by the 28th? I don't understand it. I don't think that's possible. Like, so is it,
Yeah,
is this like, yeah.
so don't think of our workshops as you having to get everything done ahead of the 28th. They're more workshops to inform and support you throughout your investment journey. So it's not a prescription in terms of what you have to achieve in order to qualify, and in order to be selected as one of our winners from the Sheboot Investment Group. But it is ongoing learning, and it is a great base to start from. I know it can feel overwhelming. And the slide deck is already made available, so it's already the information is there and stored. We're happy to follow up if you need specific support around IP, with advisory hours, or to connect you with Natalie or another resource. So you can reach out to me directly for that. But we don't mean to panic you and to set you into
No,
a
no,
spiral
no,
thinking, yeah, that you.
I'm just thinking like, if that stuff isn't in there by the 28th, like, is there even, like, how does that affect us? I guess.
I guess I can't really answer that on a general sense, as it will affect each one of your I guess, pitches in support or in your effort to get investment. So that's a difficult question for me to say, like, yeah, it disqualifies you from being one of the top candidates, or it qualifies you from being one of the top candidates. But I would just say, what this session is meant to do is to also prepare you and prep you to do to prioritize moving forward. So our investors aren't getting this solid list from Natalie. They're not watching this workshop and then saying, oh, well, if they don't meet all of this criteria, then they don't qualify. It would carry on as if you were just, pitching your business to any investor group or any individual investor. Yeah, that's basically the best way that I can answer that, unfortunately. I wish I could give you like a black and white yes or no answer.
No, that makes
But
sense.
yeah.
Okay, that makes sense. Thank you, Katie.
Yeah, no problem. And if all of you feel the IP session needs to happen earlier in the program for future reference, let us know, because we, as you know, I'm always open for feedback and eager to move around the program. We just find that in the past, when we've had the IP session a little bit earlier, it's been a little bit too overwhelming with the legal session than the financial session. And IP is more of a longer game. So we, that's why we would schedule now. But if you feel it should be earlier in the program, do let me know. Not that that helps you right now. Sorry, but it helps founders in the future. So I appreciate the feedback. Is there any other questions about expectations? No? Okay. Okay, well, I'm here. Let me know. Give me a call, send me a text, shoot me an email if anything pops up. I know it's a hectic time. And thank you all for just making this such an amazing experience for me. It's been an honor to learn more about your businesses, watch you pitch, and walk you through the program.
Can I just say on behalf of everybody, Katie, thank you, because you have been absolutely phenomenal. These workshops have been great, and it would never have happened as smoothly without you. So thank you so much.
Oh, thank you, Jane. That means a lot. I love and am honored to do what I do and to work with all of you. And I'm excited to see you all. I'm going to see you all soon. Yay. Okay.
We're all going to
Okay,
be crying
ciao.
off screen, but hugging.
Oh, yes, I will. I will 100%. That definitely on my side, that's for sure. But thank you all very much. And yeah, have a great day and we'll see you soon. Okay, bye.